afternoon, I think, is just about everybody. My name is Bojana Bellamy. I lead Center for Information Policy Leadership and really delighted to be kicking off this webinar on the latest developments and proposals for the regulation of AI in Brazil. This comes at the end of lots of work of all of us on LGPD and CIPL's Brazil project and long-standing collaboration. So I'm really delighted, and I was really delighted to see our panelists here, and I'm delighted that we've got a chance again to work with Brazil on these important topics. What I'd like to do is just literally set the scene a little bit, explain how CIPL has been working on AI, and then I'm going to pass on to Matthew Reisman, our director in US, and other team members to kick off this conversation, particularly introduce some of CIPL's more recent work on Brazil AI regulation as well, points, and then of course there's going to be excellent discussion with the brilliant panelists as ever. So please, Malachi, would you just quickly move on the slides. I mean, I think for those of you who don't know CIPL, we are global privacy and data policy think and do tank. I think when we started all the work in Brazil years ago, we were really more on a data privacy policy side, but I think the world has moved on, and this conversation shows that nobody can actually consider just one of these digital disciplines. Data has to be holistically addressed, data policy, data regulation, data compliance, and we at CIPL find ourselves thinking not just about data privacy, but also increasingly other areas like digital safety, competition, and of course, AI. As I've said, we've had a great pleasure to work on a number of Brazil projects in the past and to hear the stakeholders, and I always enjoy the conversations in Brazil. Now, next slide, please, is really important just to give you a bit of background on CIPL's interest in AI. So as early as about 2018, we looked into how does data protection law regulate AI, and where could there be some tensions between data protection principles and how they're interpreted and AI principles. And in our second paper on sort of hard issues and practical solutions, we started looking as to what could be the solutions to some of these tensions. What do we want to see companies do, but also how should regulators evolve the interpretation? And a year later, we then also published a really important paper, which I suggest you have a look at, on how does GDPR regulate AI. This is really important to mention because it is absolutely clear. It was clear to us then, before even we discussed regulating of AI, that data protection laws absolutely squarely apply to use of data, personal data for AI, for training, for AI development, AI deployment. And so does LGPD. And it does so explicitly in some provisions and articles. All the provisions, for example, on automated decision-making are directly relevant for AI or knowing the logic or being transparent about the logic. But then it does so implicitly because every single principle, from fairness to lawfulness to transparency, applies to the world of AI as well. And so I think in some ways, the conversation about regulating AI is very different in countries like Brazil or Europe, where we have got a strong and robust data protection laws, and where we have got a strong, robust, and progressive data protection authorities, because they're also able to apply these principles and evolve them in the way that makes sense as well. There are some tensions, I'll talk about that, but this is really important to understand. So when we think about regulation of AI, we then ask ourselves, where are there gaps to maybe consider with the precision targeting of AI regulation, as opposed to starting from scratch? And how can we leverage what we know from data protection principles and data protection discipline for the regulation of AI, so that we don't duplicate? That is really very, very important. Like data privacy impact assessments are a very useful tool to understand the AI impact assessment as well. or to carry out AI impact assessment. Then I just want to mention that we have been working on this topic of regulating AI for the past 2 years, as of course the world has woken up. All of a sudden, there is this new technology, and the question became, how do we regulate this new technology? And I think CIPL was a bit more cautious, and our point of view was, we really have to think about what exists already, what is missing, and how do we think about regulation of the uses of technology, not the technology itself, because tomorrow it's going to be something else. It will be biotechnology, neuroethics, it will be quantum computing. And what are we going to have these laws for every single new tech that comes on the market? And Matthew will talk to you more about, we actually published a really good solid paper and translated that also in Portuguese and Spanish and French on principles for regulating AI as a result of this work. And then finally, I do want to signal, as you know, CIPL has always been working a lot on the topic of organizational accountability. We absolutely think that companies have to be leaders in developing and implementing data privacy management programs, and the same applies to AI. So about a year ago, we embarked on a new project where we mapped and interviewed and gathered evidence of how some of the leading companies are today developing best practices for accountable AI development, deployment, and governance. And this is very important, because what this showed, and Matthew will share again more of this, is that despite the fact that there is no law, companies do understand that it is essential for them to create a product that is viable, and it is also going to be easy to sell, and that will not create liabilities as well for themselves. So there is a lot of good practice, and in this paper we actually put all of that together and tell that story. Now, if we just move to the next slide, and then I'm going to pass on to Matthew. I just wanted to mention this because I know that this audience is full of data protection experts. We've got the IMPD here as well. Very early on in CIPL's work, we identified that AI is going to start, just like some other technologies like blockchain, for example, right? Is going to actually require us to rethink and develop and evolve further the interpretation of our data protection principles. There are some tensions. There's a need for clarity. For example, legal basis for processing. What does that look like for the training phase of algorithms? What does that look like for decision making? Is consent really viable in all situations? What is the actual legal ground for processing of sensitive data? Because all the technologists and data scientists tell us we do need sensitive personal data we need to capture it, record it, and retain it, so that we can check that our algorithms are not biased, they don't discriminate, and they're fair. So in fact, fairness, there are these trade-offs in some ways, right, that are inherent in technology that we have to be able to answer from data protection point of view. Data minimization, well, really AI is all about data maximization. We need data, more data and diverse data to be able to train algorithms properly. And then purpose limitation as well. What is really the purpose? Is training of data and algorithm a purpose in itself? I think so. What is a subsequent purpose? We're going to have to think very creatively, because if we say you can't use data X for something Z, well, that's going to be very difficult for and stifling the innovation and ability of AI, because AI also doesn't know the answers until it starts actually churning data. And of course, there are more questions there as well. The transparency, what does that look like from privacy, but the AI perspective? What about the retention of data? We do need to retain data, but privacy laws require us to keep it no longer than necessary. How do we, in fact, also exercise the rights of individuals? For example, the access to data that is held in the AI systems or used to train. Is there right to deletion? Is it possible to delete that data actually, or just to block it? And then, of course, finally, cross-border data transfers. Very important. As you know, we live in the world where there are increasing demands for digital sovereignty, increasing data localization and restrictions of data flows. That doesn't really work very well with AI technology. Again, for AI and for all countries to be competitive, I feel very strongly about this, right? We need the whole world to jump on this AI wagon, not just the most developed countries. We really need to share data and make sure the data can be transferred across borders as well, for training of algorithms and for delivery of AI systems. So these are some of the tensions. They're not unresolvable, but they need consideration. I'm very now encouraged to know that IMPD is embarked on a sandbox to look into applications of AI together with privacy considerations, but also we see from other regulators, for example, here in the UK, ICO, as well as CNIL, producing some really useful guidance and answering some of these questions so that these tensions don't seem that apparent, and they provide that clarity and legal certainty to companies as well. And so really, final point, if we think about AI regulation, one thing I would also suggest, if there are any gaps or tensions that we need to resolve from data protection point of view, that may be a good way to deal with them, right? And that's what we saw in Europe with the EU AI Act, where they've actually introduced the new legal basis for sensitive data processing in the EU AI Act, and we think the UK is going to be doing the same. So that kind of very targeted intervention, I think, could be very useful. So with that, I'm going to pass on to Matthew Reisman on my team, and I'm going to enjoy listening and look forward to the discussion as well. Thank you very much.
Well, Jana, thank you. And thank you to our amazing panel that we have and the individuals who've joined. And now 82 of you on the call. For CIPL, it's such an honor to be as part of this discussion. I think for those of us who've been involved in technology policy, data policy, we see Brazil as a leader. You have been now for well over a decade, much longer, on global discussions on responsible technology policy. So it's an honor to be just a part of your discussion and to try and be helpful within it however we can. Just to go to the next slide, please, Malachi. As we think about the approach to AI governance, we're thinking about it from two perspectives. One is the perspective of government public policy. What are the rules of the road to shape it? But also there's the question of governance within organizations. What are organizations already doing? How do we identify those best practices? And how do we make public policy that supports those best practices? So we at CIPL have tried to address both of those questions. On the question of best practices in AI accountability, we've just wrapped up about a year of research where we went in depth interviewing leading practitioners of AI, including from some of the organizations that are represented on the call today, to really understand how they're trying to put these principles into practice, even as the rules of the road continue to be written in Brazil and other major markets around the world. Those who are doing AI responsibly aren't waiting. So won't go through all the findings here today, but would encourage you, if you use your phone to take a picture of this QR code, it can take you to the full report. But what we saw was truly inspiring to us, that the best in our field are already developing practices that put accountability at the cornerstone of how they govern AI. They are putting leadership in place that sets out principles. They are setting up frameworks internally that actually ensure that those principles are realized at every stage of development and deployment, and that there are loops for monitoring and for internal enforcement if folks get off track internally. So encourage you to have a look at the report to learn more about it. If you can go to the next slide, please. On that other side of the stool, on informing the laws that govern AI public policy, CIPL looks at this in to use a vegetable metaphor, 3 layers of an onion. So at the core of the onion, if you will, there's principle and outcome-based rules. We believe this is the heart of any holistic AI public policy framework. And I won't go through every word here now. You can read the full report, but in essence, this includes a technology-neutral approach. Bojana noted in the beginning the importance of focusing on the outcomes we want to achieve with our AI public policy, as opposed to focusing on any particular technology per se. The importance of a risk-based approach and the empowerment of individuals. What are the rights that we are trying to achieve and secure through those laws? At the next level of the onion is demonstrable and organizational accountability. Here again, we've identified in the report that I just mentioned, there are good practices for accountable AI governance. How do we incentivize adoption of those practices? And when things don't go as hoped, how can we apportion liability carefully with sensitivity to parties' proximity to the generation of the harms that there may be of concern? This is hard. This is complex. We may have some discussion on it further today, but this is the layer at which we see this challenging question. Finally, there's robust and smart regulatory oversight. Here, for us, the role of the regulator is not only to enforce, but also close cooperation with those in the space to make sure they understand the expectations that have been put upon them for responsible governance and development and deployment of their technologies, helping answer their questions. There's also coordination within their national governments with other regulatory bodies that may share responsibility over aspects of AIs, privacy regulators, IP regulators, competition regulators working together, but also and crucially, cooperation internationally. We all face a challenge, those of us who work, for example, or have worked in multinational companies. There's not just one country's rules that one is trying to follow, there's a globe of rules. How do we have our regulators cooperating towards shared principles and interoperability wherever that is possible? Now, to go on to the next slide, please. Just to let you know that the reports that we've mentioned, a number of these are available both in English and Portuguese, including our comments on the particular legislation that we're here to talk about today. So you can find those here. And on to our next slide, please. So now I'd like to pass the floor to our colleague, Burak Haylamaz, to draw the line between the principles that I laid out for you in our onion to our specific analysis at CIPL of how that framework has been realized in the current legislation in Brazil. Now, each of our panelists will have a chance to share their views as well. Just to kick off the discussion, we wanted to share some of CIPL's analysis from the report, whose link I just shared with you previously, and to do that, over to you, Burak.
Thank you so much, Matthew. Good afternoon, good evening to all our audience. My name is Burak Haylamaz here in our DC office. Hopefully in the next 10 to 12 minutes, I will briefly summarize CIPL's comments on draft Brazil AI regulation. As Matthew highlighted, our comments on Brazil AI bill were guided by the principles outlined in our white paper, Global AI Regulation Recommendations, that Matthew eloquently presented earlier. And in our comments, we observed that some of our recommendations have been adapted in various parts of the Brazil AI regulations. However, we have also identified some parts of the bill could be improved to better promote responsible AI governance. And we believe providing guidance, clarification, or making amendments in those areas would help ensure that Brazil's regulatory framework remains adaptive to the evolving technological landscape. So without further ado, I want to start with the strengths of the bill that we identify first. Rather than regulating the technology itself, the Brazil AI regulation follows a risk-based approach, providing different sets of obligations and governance model depending on the risk associated with AI systems. So it has the similarity with the EU AI Act in that regard. The bill prohibits the implementation and use of certain AI systems called excessive risks, such as employing subliminal techniques to induce individuals. And for high-risk AI systems, again, for instance, biometric identification systems, the bill imposes additional obligations and governance measures. For instance, organizations must conduct algorithmic impact assessment, and that impact assessment actually take into account the associated risk, but as well as the benefits holistically. Next is relationship with the existing legal framework. The bill intends to avoid duplicating or creating any conflicting requirements with existing frameworks such as LGPD, consumer protection, anti-discrimination, and IP laws. For instance, the bill's language appears that it's applicable without prejudice to LGPD. However, we encourage it will clarify whether regulation prevail in the event of any conflict or not. Another positive aspect of the draft bill is its approach to empowering individuals through transparency, explainability, and mechanism for redress, which are instrumental in achieving trustworthy and beneficial AI. However, we think the bill should avoid requiring organizations to provide overly detailed description of their complex algorithms so that organizations can provide meaningful information to average consumers. And also, those transparency and explainability rights should be balanced with organizations' legitimate interests such as trade secrets and security. Fourth is the coordination and cooperation across regulatory bodies. The bill actually creates a mechanism for that, both domestically and internationally, with the central role of the competent authority. And we believe that this approach would benefit organizations and regulators by promoting consistency, but also providing holistic interdisciplinary regulatory approach over the time. And as Boyana highlighted before, we are observing some countries like UK, the RFCF, and Netherlands establishing that collaboration across regulators. Next is that the bill prescribes the possibility for organizations to formulate a code of good practices and governance and considers organizations' voluntary participation in such practices as an indication of good faith, and they consider the bill consider that participation as favorably in enforcement actions. We believe this will create an environment where organizations use accountability frameworks to stand out and create a value in their data practices, and they may even go beyond fulfilling their baseline legal and regulatory obligations. Finally, the bill's modern approach to regulatory oversight. The bill authorizes the competent authority to create a regulatory sandbox regime for the purpose of encouraging innovation in AI. And we believe this provides supervised safe space for organization to address and resolve some of the most challenging aspect of deploying AI applications, particularly when they appear inconsistent with the prevailing legal requirements. So if we can go to the next slide. We also think there are certain areas that may require further development that we highlighted in our paper. For example, the bill prescribes a blanket prohibition of AI system with excessive risks. And we believe instead of a blanket prohibition, we recommend the bill should treat the level of risk as rebuttable presumption. So this would enable organizations to consider the highly contextual nature of AI applications and give them the opportunity to demonstrate that the use of AI application in that specific context may not present like excessive or high risk. Then the draft bill uses some concept and terms that we believe require further specifications, maybe in the form of regulatory guidance too. And notable examples include the definition of AI and the AI, the players of the AI ecosystem, AI supplier, um, operator, agents, and people affected by AI system. And we encourage the draft Brazil AI bill to leverage existing and emerging soft law frameworks and their terminologies, such as those produced by the OECD. And in doing so, we believe it can foster international alignment on AI regulations. And third one is about the liability. As Matthew highlighted, the draft bill should treat all actors with the process similarly, as it would create significant negative effects on smaller entities, open resources developers, and innovators. And for that, the draft bill and regulatory guidance should target appropriate liability apportionment across parties in the AI ecosystem according to their share of responsibility and generating a responsibility for generating harm and their ability to mitigate such harm. We already highlighted that there is a very positive sign in the bill that the competent authority engaged in creating regulatory sandbox, but we are concerned that about the continuous liability of participants in the testing environment. That's something that we also observe in the EU AI Act, and we recommend that participation in the sandbox be treated as significant mitigating factor in enforcement actions if any alleged violation relates to activity that was or in part of the sandbox. Otherwise, we think organizations would be disincentivized and unlikely to participate in regulatory sandbox and collaborate with regulators on responsible deployment of emerging technologies. And finally, the bill requires the creation of AI public database that are accessible to public and contains impact assessment. And our concern is about the feasibility and advisability of such AI database. And we believe accessing to this database should be subject to appropriate safeguards to make sure that the confidentiality of personal data is achieved, and there might be also legitimate business interests or other information could be leveraged by malicious actors. So in order to prevent that happen, we want to see there are some appropriate safeguards to be taken by the bill or the regulatory guidance coming up later on. So with that background, I will pass back to Matthew, and hopefully we will start our panel discussion.
Barak, thank you so much for that overview of CIPL's analysis. Before we go forward into sort of full discussion, first of all, I know that many on this call have spent many, many hours analyzing this bill closely. Some of you have played seminal roles in developing the legislation. But before we go further, I first wanted to provide the floor to Miriam Wimmer, Director at Unpaid A, and Tiago Luis Sombra, Partner at Matos Filho. First of all, to fill in any summary comments that we may have missed in terms of key features of the bill. Is there anything that was not mentioned by Barak that is a key element you would want our audience to be aware of, but also to give you the right, both of you, a first response to our analysis and points upon which you may agree or disagree, but then I will turn to each of our additional panelists to also share their own summary comments on key features of your analysis or points that you may agree or disagree with of our analysis. And to our audience, please recall there is a Q&A feature where you can place comments and questions in the chat. Thank you. And why don't we turn to you, Miriam, over to you to start.
Thank you very much, Matthew. Thank you for the invitation to take part in this discussion. And I think, in fact, Barak's analysis covered many of the important features of our bill. I think I'd just like to add that, to give a bit of context to our discussion, that although our bill has begun moving more quickly in recent years, AI is not really a new discussion in Brazil. In fact, Brazil was one of the countries that adopted the OECD principles in 2019. We have an AI strategy that was approved in early 2021, if I'm not mistaken. And at the same time, although we are now discussing Bill 2338, there are also other bills that are going through Congress that were proposed some time ago. So I'd say we are at a stage where we are gaining more maturity with regard to this discussion. And I think a point I'd like to add as well is that we currently have perhaps two models that are on the table and that are somehow competing for attention within Congress. So on one hand, we have a bill that was approved in the Chamber of Deputies, our lower house, which is very similar to the OECD principles, in fact. So very light touch, very principle-based, general commands, a strong belief in the ability of the private sector to self-regulate. And on the other hand, we have Bill 2338, which we are discussing at this point, which is, of course, strongly inspired by the European approach, but I would argue also brings sort of a tropical flavor. In fact, it's important to note that this bill was discussed by a committee of legal experts where Thiago and I both had the honor to serve and to participate. And we had a huge focus in actually providing an environment of public discussion that would allow us to make informed decisions and also to adapt our approach to our own specific realities as a country in the global south, a developing country, with needs and requirements that are not necessarily identical to those in Europe. So in fact, we had public hearings with more than 50 experts. We have over 30 hours of recorded discussions. We had written contributions from societies, government, academia, private sector. We had an international seminar, we had international benchmarking, and of course, CIPL contributed greatly to these discussions in different moments. And I would say that perhaps one of the most important aspects that I think slightly bring the Brazilian AI bill away from the European experience is that while the European approach, as far as I understand, was initially very concerned with product safety, in Brazil, I think we started from a point of view of protection of human rights. So this is based also, of course, on our experience in Brazil with legislation on digital rights, in particular our Marco Civil da Internet, which is our internet framework for the internet with rights and responsibilities and duties. So I think one important aspect that makes our bill a bit different from the European approach is the fact that we have a whole chapter on human rights that include many rights that are actually quite close to what we have in data protection. So rights regarding transparency, access to information, the right to an explanation about the decision, the right to challenge decisions or predictions of AI systems that produce legal effects or similarly impact the interests of individuals. And of course, an important focus on non-discrimination, correction of discriminatory biases. Of course, these elements are also available and present in the AI Act, but I would say that our initial focus was perhaps stronger on these aspects than the European approach. I think I'd like to hand it over to Thiago to speak a bit more about the risk-based approach, or please go ahead, Thiago, if you like.
Thanks, Miriam. Thanks, CIPL. It's a pleasure to be here with so many good friends addressing what we believe were the most relevant topics that we tried to cover in this draft bill. As Miriam highlighted, probably I would just mention at the beginning, Burak, we had draft bills under the Congress analysis since 2019. So even before the pandemics, the Congress was already reviewing and discussing AI as a proposition to have a bill very soon. So other than the fact that Brazil was part of engaged in the OECD principles, so we had an internal, let's say, pressure under the Congress to pass a draft bill in order to regulate. Sometimes from a soft perspective, from a soft law perspective, other from sometimes looking for a more concrete and specific regulation. From the beginning, when we were together, the group of scholars that worked against this draft bill, something that was very clear for us is that we didn't want a kind of soft law, such as the Biden-Harris commitments. We are a civil law country with a civil law tradition, so it was very relevant to have a bill addressing specifically not only rights and guarantees, but also enshrining some topics that would probably guide what we do believe are the future of the AI in the country. But you mentioned the pressure that we had here in the country from, I would say, the private sector, but the public sector as well. Today, I would say that most of the public policies that was issued by the former government and the current government, most of them applies or employs artificial intelligence tools. We have the Federal Court of Auditors, our antitrust and our anti-corruption bodies using AI tools, the Ministry of Health, Ministry of Education. So there are a sort of matters that are really relevant for us and that requires, from an internal perspective, a regulation of the law. This draft bill has specifically, I would highlight 4 pillars that are very relevant to us to address and compare with the one that passed last week in EU. The first one deals with rights and guarantees, which somehow have some topics that are almost similar, but we have a more specific one just being highlighted regarding human rights, and we address specifically autodetermination, non-discrimination, but precaution and prevention as relevant topics that we also brought from other regulation that we have in the country, specifically the environmental one, that probably fits specifically and fits very well in the discussion that we faced here in this law. Other than that, we have a specific section related to categorization of risks and the evaluation of risks, which is a kind of mix of regulatory approach in which we address a core regulatory approach with a self-regulation perspective, in the sense that all operators would be allowed to have an internal assessment before launching an AI tool, an AI technology to the market. And finally, I will address two other specific sessions, one related to the AI agents, which embraces the operator, and the one that provides the technology or the system. And finally, the liability, which is probably the topic that we had most difficulties to address, especially because we have several members in our group, some with different perspectives, some are more consumers, other ones are more focused on data protection. But at the end, we tried to find a common understanding that would better address what we believe. I'm not sure if we embraced the best model, liability model at this current stage, but we do have a tropical flavor in this draft bill that requires a little bit of improvements, but certainly under the Congress analysis it will receive, although we have several hearings. We received suggestions for, I couldn't remember the number of individuals, but we brought specialist experts, scholars, and also the market to comment and provide more guidance for us. So I would highlight how representative was this. I would say, since we are in the 10th anniversary of the Internet Act, I would say that this draft bill may have even more representativeness than the Marco Civil, because it was discussed at least in 5 different cities in the country and received suggestions from people all over the world, from the regulatory perspective, from government and scholars. And finally, just to stop my first takeaway here, I would mention that here what we are trying is not following exclusively what EU did, but trying, just as we did with the LGPD, to give a perspective that would probably creates a balance in between rights and guarantees and what requires a boost to the market in order to have better tools that would provide to our population even more better services from a public policy perspective. I switch to Matthew, and please, thank you.
Miriam, Tiago, you've given us an extraordinary description both of the context in which this legislation is happening, the broader context and evolution of regulation on AI and technology in Brazil, taken us through some of the most important facets of the law, including some that we didn't discuss in our presentation, and deeply grateful to you for that, and also pointed out some unique aspects of this that make this a singular piece of legislation in the region and the world. I now want to turn to our other panelists to share their perspectives on what they've heard and also what they've been analyzing over these past months. So let me first turn to Diego from Meta to share your initial thoughts, and this is in no particular order, but we'll just go through all of our panelists to share their views. Over to you, Diego.
Thank you so much, Matthew, and thank you so much, CIPL and Boyana, for leading this team that brought us together to discuss such an important topic in such an important juncture, I would say, for the future of AI regulation in Brazil. I mentioned important juncture mostly because we are at the brink of seeing a new text in Congress that was promised by some of the senators that are part of the current committee dealing with the matter in that specific chamber of our Congress, which comes right after the European Union took final steps in the adoption of the EU AI Act, and also actually come in a moment that is ahead of the upcoming elections that are going to take place in October. So I think it was a very, very timely discussion for us to be able to advance. I just wanted to highlight that I feel really, really happy to be here among friends, not only colleagues with whom I learn a lot on a daily basis, but friends from the old times of the Brazilian Internet Bill of Rights, LGBT discussions, and so on and so forth. So I just wanted to connect 3 dots that previous speakers mentioned here. I really think that CIPL's onion model presented by Matthew gives us a snapshot of how complex and what are the 3 parts that have to be combined for us to have proper AI governance that is conducive to innovation, economic development in a country like Brazil, and also rights protections. And then going back to what Miriam just said and Tiago touched lightly, we've seen different regulatory proposals that steered, let's say, public debate. And as some of these regulatory proposals are closer to the center of the onion, and the current bill that is actually around being discussed in the Senate is closer to the edges of the onion. What we've witnessed in the past year in which people were discussing the best regulatory model was just like advocates of each individual layer as if they were opposing solutions for dealing with this animal called artificial intelligence. While I think that it was really, really fortunate that that CIPL put together this scheme showing them in a onion format, because we need to figure out how to connect the more abstract principle-based parts of this and the more, let's say, granular aspects of the regulation. And I come back to this moment because I think that despite of all the great work that the Committee of Legal Experts did in the Senate, despite all the participation, we still need more in terms of figuring out how to connect the center of the onion with the more granular aspects of the outer layer of the onion. Mostly because, especially if we consider the Gen AI animal that we now have to deal with, the governance part, the different operational aspects of the day-to-day development operation of those AI systems, they are very hard to be translated into legal normative commands at the outer layer of the onion. And despite of the fact that we've reached a common, solid, closed regulatory proposal with Bill 2338, in the past year or so, discussions around the nitty-gritty details of the proposal have revealed that we still have a lot to do in terms of flexibility for us to be creative in how to communicate the details of AI system in a meaningful way to the users. Modalities of explaining what these complex systems do in practice in a way that serves the purposes of the regulators and the oversight authorities, but also do not endanger the free development of business models. And also we still have to strike a balance between governance structures and accountability structures that do not merit for a one-size-fits-all solution, bearing in mind the complexity of the AI development chain and the market in a country like Brazil. So I think that one of the key learnings of the past few weeks or months is that even in the European Union, where several final decisions were taken on the EU AI Act, there's a significant amount of work over the coming months and the years ahead, where EU institutions will have to work in collaboration with the industry, with standard-setting organizations, with individuals, and not only at the European level, but also across the borders of the European Union, for us to fill all the gaps that are still there in the regulatory proposal. And I think that actually shows us the way that we have to follow here in Brazil to ensure that the final solution, regulatory solution, takes into account all the complexity.
Diego, thank you so much for your analysis and also for connecting what we're seeing to things happening on the other side of the Atlantic. And that comparative analysis is really helpful for us. Samantha, I wondered if I could turn to you next. I know you've been thinking about some of those same questions as well. So over to you.
Thank you. Good afternoon for all. I'll start to saying thank you for the invitation to be here for CIPL, and congrats for the great work and contributing with our Brazilian discussion here. And to all my friends, it's a pleasure to see you all again. And I couldn't agree more with Diego. I think we discussed a lot in the past few months about the AI regulation that we desire and inspire a lot in European model. But we are talking about an artificial intelligence, which itself is a complex subject changing on daily basis. For example, Gen AI. And the bill itself contains rooms for improvement, change that can be positive and could bring more dynamism to the AI sector, especially when we are talking about this Gen AI, that it's not 100% covered when it's the first draft was made. And changing the approach could also have an impact in the articles concerning to the civil liability and the sanctions that, as Thiago mentioned before. And I think that's my little thoughts to start this conversation.
Thank you so much, Samantha. And I will just take a brief pause to point all of our panelists to the questions that are showing up in the Q&A, with gratitude to you and those who are attending, who are posing these great questions. After each of our panelists has a chance to make these initial remarks, I will invite our panelists if they would wish to respond to questions in the Q&A. Felipe, let me turn to you now.
Brilliant. Thanks, Matthew. Thanks so much, Matthew, Boyana, Burak, Malachi. Thanks to the CIPL team for getting all of us together and allowing us to share our views. My brief comment would be that I think that the end result is clear for everyone, what we want to achieve. We want companies, to translate principles and to be mindful of people affected by AI. Making sure that companies are adopting, safety, and all of those requirements that would make life safer for people using AI. The method we're choosing to do that, that's up for discussion. And in my view, there's definitely room for some improvement. There's so many strengths in this bill of law. The way that it's principle based, the way that it addresses risk assessments, how it allows companies, and how it, to an extent, incentivizes companies to adopt codes of conduct, and to seek out certifications. But at the same time, there is some room for improvement. There is some room for us to be more aligned with other, initiatives in terms of the definitions we have for suppliers and operators. In our case, in terms of civil liability, how that translates into how we place liability between those agents, responsibility between those agents in terms of how companies are required to meet, the rights of people affected by AI, and to what extent those rights should be exercised. Like when to provide information, in what format, to what's the depth of information that should be provided. So all of those aspects are up for discussion. All of them are up to either refinements when we're drafting the bill of law itself, or up for additional guidance once the bill of law is approved.
Thank you, Felipe, for pointing us to both the many strengths and some additional potential areas for work. Renato, I'd like to give you an opportunity to share some initial thoughts.
Sure. Thank you, everybody. Thank you, CIPL, Boyana, Matthew, Brock, Malak, and all the fellow panelists that we've been on these different battles and challenges here for more than a decade, with a lot of victories and a lot of lessons learned over here. So I really, truly appreciate the effort that led to the bill 2338. I followed all the work of the commission, of Miriam, of Thiago. I had a chance to participate in a Senate hearing about transparency obligations and right to explainability and so on. And as Mira mentioned here, we do have two competing models, at least in Brazil. But if we were to look at the rest of the world, like the last time that I saw, we have right now 127 countries attempting to regulate AI somehow. Yeah, and we look for here for the EU, what we call the Brussels effect, because maybe even in Brazil, but in a lot of parts of the world, that's where we had a tradition to look up. But I think we do have the opportunity here to look at other models, not only the Brazilian or Southern flavor, but also maybe a combination of what we seen in other parts of the world. And I think even on the panel today, we had the opportunity to talk a little bit about some of them. Two items here that I would like to focus on these initial thoughts about the current version of the Bill 2338. First, I think the same way that the AI Act did not have a lot of time to properly discuss and embed and even regulate general purpose AI, foundation models, generative AI. I think also on 2338, we don't see a lot of the elements that we need to take into account for this, for general purpose AI. And I think we have I think this is a moment that we have to also include in this some of the aspects out of this. For example, and I think we're also going to have the chance to discuss this on today's panel, on the current version of the bill, where it talks about general purpose AI, and says when you have general purpose AI, you have to describe the use cases of this general purpose AI. I think it's like, how am I gonna? We don't even know. And this will go to the other element that I think we should try to focus on as we continue to discuss the bill, is how we can create incentives to take some of the regulatory sandbox approach over here. And we come to liability to go for those who, instead of launching services into the wild, let's call like this, but before doing that, go into a regulatory sandbox or a more controlled environment. What are the mitigations that on liability of the different actors and the different agents that we see in the ecosystem, how that could be create a bigger incentive. And the other part here that I would also like to see us further discussing is about the confidentiality of the impact assessments. And I'll also make here one analogy, and Boyan and Matthew, you know this. Right now, as we are discussing in the EU, the attempt to reform the GDPR, one of the biggest issues that we look over there is confidentiality of the documents that we share among with different data protection authorities in the different countries over there. We've seen some situations, and I am talking here from the privacy sector, for a company that does share and engage a lot with regulators. We do share documentations, not even in informal process, but more in the informal engagement. If we are not really sure of how confidential that can be, to a point that we are still assessing the risks of a service and a product into development, I think that will not create a good incentive will not create the incentive that we want right now. But I'll pause there. I think there are other items that we need to discuss here. But again, thank you, CIPL, and everybody who's listening right here.
Thank you so much, Renato. And all of the commenters have raised issues that I hope we can return to, time permitting. Things like liability, generative AI, general purpose AI. Before we turn to those, actually, one of the questioners or attendees has raised a question that dovetails with the next item that we had planned to discuss, which was around the regulatory framework for the bill. I'm actually going to read the question that was in the chat, and Miriam will give you the opportunity to respond first. And the question was, what do you think about the AI bill and its directive of delegating to the executive the attribution to choose a regulatory agency for AI? Moreover, what do you think will be the role of ANPD on all of that? Will ANPD be the delegated agency? So if you'd care to respond to that and any broader themes you may want to address on the framework.
Of course, thank you for the question. And in fact, as many of you know, the bill in fact says that it's up to the executive branch to designate which public body will hold this important role of regulating and enforcing the bill. And I think it's important to clarify, especially for an international audience, that the reason why the bill does not directly state which body will be taking on this role is because there is a constitutional limitation. So Congress is not entitled to create new bodies within public administration or to deal with issues regarding public administration. So this technique is actually correct from a legal standpoint, to say that the executive branch will define who is responsible for this. And this authority, this supervising authority, will in fact have several important competencies. And I would say that perhaps the most important of them is in fact to bring cohesion and coherence to an extremely fragmented institutional framework. Because in Brazil, as in other countries, AI is a technology that affects all sectors. So potentially you would have a very large number of regulatory agencies or consumer protection bodies or other public organizations somehow involved with the issue, possibly issuing rules, potentially applying sanctions. And when we have such a cross-cutting legislation as this bill is, it's super important to have a central authority who can bring some sort of consistency and cohesion and a uniform interpretation to the bill in order to provide for legal certainty. Now, this is a discussion that is very similar to what we had when we were discussing the general data protection law in Brazil. Boiana will certainly remember. So initially, there's this tension between sector-specific and cross-cutting. This is something we have in Brazil. So some actors would argue that it's better to leave AI regulation up to regulatory agencies in their own sectors, while others would argue in favor of a more cross-cutting approach, which is what we are debating here at this point. And then the second point is how to make this general legislation coexist with sector-specific rules that may potentially bring tension or even different approaches or different regards towards the same issue. Now, what I would say is that while there is still no consensus within the executive branch on who this regulatory authority will be, it seems to me to be absolutely vital to have this central point of coordination. And the second point I'd like to make is that from our perspective, speaking from the Data Protection Authority, ANPD is already well positioned to take on such a role. This is a position we have expressly stated through technical documents. We have taken this position to public hearings in Congress and other places. And our argument is that, in fact, since our law is so strongly geared towards the protection of human rights, many of which are quite similar to those that are already within the general data protection law, it would be very confusing to either create a new agency or to attribute these competencies to an existing body, potentially creating more confusion, more conflicts of competencies, and ultimately more legal uncertainty, both for companies and also for data subjects. So I think this is an interesting point for us to debate, and I note that it's a debate that is also going on in other countries, right? So I note that EDPB and EDPS have already mentioned that the designation of data protection authorities as national supervisory authorities would ensure a more harmonized regulatory approach and contribute to the consistent interpretation of data processing activities, which are, of course, fundamental to artificial intelligence, as Boiana already noted earlier. And I think that as we discuss this point, it's important to note that the issue of AI is already a part of our regulatory agenda at ANPD, because our law already provides for points such as the right to an explanation, the right to challenge automated decisions, as well as transparency and access to data obligations. And the second point I'd like to state is that in the spirit of promoting responsible innovation, we are also developing and working on a regulatory sandbox on AI at our DPA. And the focus here is to better understand through an experimental environment with dialogue with the interested parties, how we could interpret the right to challenge automated decisions and the right to an explanation, especially when we are discussing machine learning applications. So directly to the question, I don't know if the ANPD will be designated as the responsible supervisory authority, but if in fact the law is approved with this cross-cutting characteristic, I think ANPD would be in a good position to take on these additional responsibilities.
Miriam, thank you so much. I'm going to open to the floor, but at first I want to give Boiana, I see your hand, if you want to take a moment to respond.
just very briefly, because I cannot resist when I hear Miriam's brilliant explanations, but also the other comments. I think there are some really interesting parallels in how this bill is going through the process with the LGPD. And by the way, I really loved the fact that it really was a multi-stakeholder approach. And that's something that Brazil does so very well. It did that incredible job with LGPD. And now to hear that there are so many points of view taken is really excellent. I wish that was frankly done elsewhere. But on the point of regulator, it really is this is a very complex topic, and there is no one way in which any country can or should go. In the UK, where we are not going to have one law, but each of the sectoral regulators has been tasked to actually regulate and adapt their law to the new world of AI, I think that's the right way forward. In the world of Brazil, where you might have new rules, I then think it's really important that there is consistency in how these digital, technologically advanced rules are interpreted together with data protection. And I can see lots of benefits for this being the same regulator, because I can't, the digital, ANPD and data protection is a digital regulator by default. And while, Miriam, I totally agree with you, of course, fundamental right protection is something that really matters a lot. And this is part of the role of a regulator. But I think regulator also needs to ensure not just fundamental rights, but this responsible use of data and accountability of organizations, and has to look, I call this a dual role. They have to have one hat, fundamental rights, and one other hat in the digital reality. So you are already able and capable of doing that. ANPD has learned and is doing that very well. I don't think every DPA does that in the world, but I think ANPD does. And I think it would be really dangerous to now start with a new regulator who has to think in that dual way. Because for AI, it's very important, even more than in data protection, that we do not only look at risks, but we also look at benefits. And this was mentioned before. It's important to understand what is the benefit of using an AI technology in health, in education, in a company for productivity, in so many finance, fraud prevention, cybersecurity, huge applications, right? And what would be the benefit and the risk of not using AI also must be taken into account, as well as risks of using AI. And I think that's ANPD is in a good position to take that balanced approach, because they, I think, are doing a good job with the LGPD. But that's in AI even more important. Now, we just have our executive retreat in Madrid, a CIPL executive retreat, and this was a big discussion at our retreat. And some data protection authorities feel very strongly they're only there to protect the fundamental rights. They can't look at the benefits. And if that's the case, then they can't be the regulator of AI. And also, AI is bigger than personal data, right? So it's bigger than just personal data. So these regulators must be able to think broader. And this is where the benefits as well come into play. So I'm agreeing with Miriam, absolutely. I don't think that's the way that every country can do. And I think the data protection authorities really need to step up globally to be able to have this dual point of view and dual point of consideration. I have some other comments, Matthew, but later I want to hear the conversation. I have some other comments on the other points, but
Great.
we can do that later.
No, thank you so much. Our discussion is picking up momentum now, and to keep that going, I'm going to go to Renato next, and then Diego, I saw your hand as well. So Renato, over to you.
Real quick over here, because this is something that I had the opportunity to discuss with Mia and others before, and we had the opportunity to discuss this recently in the CIPL executive retreat in Madrid. That GPAs, and I've always been under the impression since we started to discuss LGPD that the goal of a data protection law was not only to protect the fundamental right to privacy, but protect fundamental rights. I even had opportunity to write down this in some of my research, and Miriam was here in my bench of my PhD, and I specifically write that down, that I see data protection regulation as an umbrella type of regulation that will protect the right to proper employment, health, and many others that we see in different ways. So, and something that we recently had the chance to discuss with other GPAs was that GPA should like focus or at least try to focus on what we call, and I quote here, Boyana, on the free movement of data, and not only the protection of personal data as mandated by data protection laws. And that's because what we see is that, I guess, for the first 30 years or 40 years discussing privacy in a silo, but now, again, let's take a look at what's happening in the EU, that you see so many different regulations that direct or indirect touch on data, not only personal data. And even when they touch on data, this will have an impact on people somehow, collectively or at an individual level, that will impact their fundamental rights. Yeah, so I do believe, and I agree here, that in Brazil, ANPD is better positioned not to be like the entity that will be there to protect the fundamental right to privacy, but other fundamental rights that can be impacted by the proper and free movement of data.
Thank you so much, Renato. Diego, I want to give you an opportunity to weigh in here as well.
Yeah, I was going to give up on that because it was a bit off topic, not entirely off topic, but as Boyana said, I also cannot just like hold myself, and I have to speak some.
You don't have to. Go ahead.
Yeah, no problem. And when Renato raised his hand, I just decided to yield to the older person for a show of respect. No, kidding. I'm older than Renato, but or not. I don't know. I just wanted to touch on two different issues here. And this is not a disagreement with Miriam, but it goes to the bottom of what Boyana said. And I'm going to speak that on my personal capacity. I think Miriam knows that I'm an institutionalist as an academic, as a trained political scientist. And we have to bear in mind context in which the creation of ANPD was discussed, in which we had almost 40 years of accumulated discussions on how to set up ADPA roles, so on and so forth. And what we now have in terms of this, this great exercise of rational institutional design, basically the whole framework that was created in the European Union is still up for tests and for us to see what is going to happen with this complex, multi-layered institutional framework that was put together there. And once again, this is basically to say that I think that the more we use the current legal framework in Brazil, going back to what Boyana said in the beginning, identify legal competences that are already enshrined in law, and then try to work only in the gaps and the margins in that bit, for instance, related to non-personal data and how to deal with non-personal data instead of just like trying to reinvent the wheel for personal data protection, is going to help us blend a better institutional framework for dealing with artificial intelligence. And this is basically to say here an additional flavor to what has been happening in Brazil in the past few years, especially focusing in the foreign audience. ANPD issued a preliminary opinion on 2338, if I'm not mistaken, right, Miriam? And also then a final position on the matter. And they correctly identified that not only 2338, but several other bills dealing with the digital, as Renato correctly put it, just like misinformation, youth online and safety protection, digital markets, and so on and so forth, they tend to overlap with LGPD. So I think that what was correctly documented, not only by the Brazilian DPA, but also by several scholars and several organizations, is actually a corroboration of what has been previously said here, that perhaps we already have a sound institutional framework for dealing with the personal data protection aspects of artificial intelligence in Brazil, and that has to be reconciled with the proposal that has been put forward in the Brazilian Congress, not only in the Senate, but also in the House as well.
I want to ask if any panelist wishes to respond to Diego's comment. I will also, as you contemplate whether to do so, there was an interesting question in the chat that also flagged that in addition to data protection, there are other elements of law that are interesting to contemplate whether the legislation sufficiently addresses things like intellectual property. But wanted to ask whether anyone wants to respond to Diego's comment. Otherwise, I'll move on to another topic. Okay, we'll leave it there on that. I do want to pivot to a topic that is close to heart to almost everything that CIPL writes about, which is organizational accountability. This is something we talked about both in the context of our governance, organizational governance work, but also regulation. And we believe that legislation has a key role to play in promoting responsible AI through demonstrable organizational accountability tools, things like codes of good practices, things like sandboxes that we've talked about already. Felipe, I wanted to turn to you first to respond. Do you think that the legislation does a good job in sort of incentivizing adoption of tools of accountability mechanisms, or is there more that needs to be done here? Any thoughts that you may have in this basket?
Yeah, yes and no. I think that the Bill of Law does a good job in making sure that companies understand that they actually need to translate the legal requirements and those principles set forth by the bill into concrete measures. They need to translate them into measures to consider safety, risk, and so forth. So that's good. That's good stuff. But then at the end of the day, the fine tuning is still up for discussion. I do think that in terms of the accountability requirements and documentation and reporting requirements, there might be an argument that those requirements are too strict, and that they may create a burden on companies. It may be cost or time prohibitive to engage in those documentation and transparency requirements. I do think that there could be, and again, it's an easy position, mine, isn't it, to sit here and say all of that. But I'm doing it just to foster debate and just to get conversation going. Those are important topics for us to discuss and make sure that they're exhaustively discussed before the bill is approved. So again, to that end, I do think that there's room, I guess, for more discussion and for more consideration on how much the law recognizes and incentivizes certifications and adherence to self-regulatory or co-regulatory commitments, and at the same time whether that could be considered as a risk like a mitigating factor during enforcement. But that said, moving on to a very practical point of view, I think it's absolutely positive that the Bill of Law takes into consideration codes of practice and incentivizes companies to adopt codes of practice. I think that there's a close relationship between CIPL's framework and what the law sets forth, in terms of making sure that companies and their accountability programs take into consideration risk assessments, have policies in place, procedures. I don't think that the bill talks about training, but transparency, monitoring, response, all of that. We do have experience with implementing all of that when implementing our IP programs or data protection programs. So there's a lot that companies could leverage from existing practices. I guess overall, it's just a matter of fine-tuning exactly what is it that's expected from companies, and just making sure that we're not creating a burden that would be too time-consuming or cost-prohibitive for organizations.
Felipe, that's terrific, and I know another of our panelists, Samantha, has been thinking very deeply about this topic as well. And Samantha, I want to give you an opportunity to respond to perspectives we share.
Yes, Matthew, thank you. In addition to the flip just said, I want to start giving a step back and talking about trust, because the trust, that's what company pursue to get from its users a healthy relationship based on truth with its user and society. In simple way, the trust relies in the organization skills to define and maintain accountability structures and governance programs that provide policies and procedures that allow them to show ethical and explainability in accordance to legal frameworks and also to the technical standards. And in this context, certifications, audits, codes of conduct, and assessments are useful tools to demonstrating that accountability. It's becoming more common to see accountability frameworks available that can be useful for providing AI governance programs such as NIST and AI model framework from Singapore and so on. In the Brazilian project bill presents 5 components related to the governance measures applicable to all AI systems, regardless of the associated risk. Are they 1, transparency, 2, measures to mitigate, prevent potential discriminatory bias, 3, legal regulatory compliance, including privacy by design and privacy by default, 4, adoption appropriated data governance parameters related to the test, training and validation of the results, and 5, security by design. Although not foreseen, we can add to the scope of the adequate data governance, adoption of the privacy-enhancing technology as a responsible AI governance practice, including mechanisms to encourage its development and broader adoption within the organization. I'd like to highlight CIPL's recommendations consistent with risk-based approach and tier approach on AI regulation. And I think everybody wants to read the paper in more detail with Coming and Home. But according to the CIPL, the responsibility structures consist of accountability, business sustainability, and protection for individuals, which is almost everything that we are talking about here and could be supported by 7 components that includes all of the 5 we already have in our Brazilian bill. 1, leadership and supervision, which includes, among other things, a public commitment of the organization to respect ethics and values in the AI life cycle. B, ethics councils and ethics committee. 2, risk assessment, which also include algorithmic impact assessment and a lot of impact assessments that can be done, including data privacy impact assessment. 3, policies and procedures, which represent an internal document that covers control implemented over A, how we use AI in the company, whether we consume from third parties or develop internally. B, privacy controls and applications. C, information security controls, such as encryption, pseudonymization, tokenization, synthetic data, among others. 4, transparency. And here, I know Renato can talk much more about this topic than me, but we have different levels of transparency according to the audience involved, like individuals, regulators, partners, and so on. Algorithm must be transparent in these decisions, must be explainable in order to make it traceable, allowing audits. It's also important to explain to the users what figures an AI decision and what means machine learning decisions to demonstrate that they are different things. It's important because the impact will be different in each circumstances. Transparency centers on data governance means also we can inform users and also society about AI data treatment through data accessibility, data lineage, data quality, among others. 5, and it's also important, training and awareness, training all companies' employees on ethics in order to be inclusiveness, include designing practice that can help developers understand and address potential barriers that may unintentionally exclude people. Additionally to the training, all employees about the company principles and values to achieve accountability through transparency in order to allow AI must be explainable. 6, monitor and verification, and the last one is answer and application, which includes, for example, human repair, not a bot, feedback channels, and mechanisms to remedy and AI decisions. CIPL is very similar to the, this recommendation by the CIPL is very similar to the data privacy governance wheel. So I think it's also a good example for how we can inspire to adopt these controls in our AI governance program.
Samantha, thank you so much for that comprehensive overview. You're pointing to some of our favorite topics. And again, to return to a theme from the beginning, our belief is at its best, good regulation is favoring and incentivizing the take-up of just the sort of practices that you described. So we really appreciate you pointing to that. It's hard to believe that our time is already drawing close to the end of what we've allotted. I want to leave time for two topics that I know have been raised by some questioners and by our speakers already. One is liability, and then generative AI, just to preview those. Tiago, if I might, turn to you quickly on allocation of liability, and after you share some thoughts, if others want to quickly respond. How can you say more about these questions around the allocation of liability among different stakeholders in the AI ecosystem, and how the bill has addressed that? Is it where it needs to be, and is there more to be raised?
Thanks, Matthew. Well, this is a very interesting question, and I can explain to you why. Since the Constitution entered into force, we have a tradition in the country in order to pass laws that mostly address the joint liability and strict liability regime. Since 1989, probably the only law that we passed since then was the Civil Code that has a legal regime of what we call subjective liability, or liability that requires the proof of damages and guilty. Other than that, this is a kind of Brazilian passion, I would say, more than soccer, Matthew, the joint and strict liability regime. Almost every law addresses the strict and joint liability regime, and the draft bill is not different from that. LGPD at certain point created an issue where or not the joint and strict liability regime was the one that was accepted by the law. We were defending until this moment that the regime was not the joint and strict liability, but some justices and some judges, there are some case law that addresses that the joint and strict liability is also part of the LGPD, since there is a kind of similarity with the Consumer Protection Code, which is not something that the Commission and the group had in mind at the beginning, because this was expressly discussed in the Congress. And at that time, under the group, the strict joint liability was left behind by the group of scholars that were working the LGPD. Here, when we were discussing the draft bill, the AI draft bill, the same discussion came, where or not should we address the joint and strict liability regime. At the end, this was the regime that was enshrined by the law, and it is addressed here. I'm aware that in EU and the other countries, this is not the legal regime that was adopted of most of the initiatives that were discussed, and this may create a problem for us, because whenever we were discussing or developing an AI tool, sometimes it will not be possible to segregate the participation or the role of each developer or each agent in the whole supply chain, where it starts its liability and where it ends. We received here, Matthew, in a congress that we hosted here in Brasilia, the professor Frank Pasquale. And Frank Pasquale said that in US, they were trying to address two specific ideas that probably could solve the problem, which was labeling and watermarking, which would be that a developer could have the possibility to segregate or limit its liability, providing a labeling or watermarking in its solution, addressing the purposes and for what purposes and what sort of AI tool he was developing until that stage. At that state of art, this solution would serve for specific purposes. If someone get it at that stage and develop it from that moment for other different purposes, what we should have here is a segregation of liability in order to not impose to him a liability that covers everything that he was doing at the end. So if we do that, if we implement Professor Frank Pasquale idea here, what we will have in mind is a kind of liability that will requires an evidence of guilty or proof, which would bring us to our former regime. It would be a subject liability regime. So this is what we are still discussing. I'm not sure if this regime will prevail, but this is something that will require a little bit more debate. And thanks again.
Tiago, thank you. And that was so helpful. And I'm realizing we could go at least another half an hour, but we only have 4 minutes left. And I want to give each of our panelists an opportunity to say anything that you felt was really important to land, but that you haven't had an opportunity to raise. I'm just going to start with Miriam, to you, and then we'll go down and give every panelist a follow-up.
Thank you so much, Matthew. Since we only have 3 minutes at this time, I'd just like to say thank you for the opportunity for this discussion. And I believe that from this debate, several interesting topics emerge that could be the object of future webinars. So thank you for the opportunity, and I look forward to continue engaging.
Thank you so much, Miriam. Samantha, over to you.
I'd like to say thank you all for the discussion, the great discussions that starts now, but we'll continue talking. So thank you very much.
Diego, any last points that we missed? Or anything you'd like to?
I had a couple of them, but after Miriam and Samantha, I just wanted to say that it was a really great opportunity for us to identify the upcoming topics of the upcoming webinars that we hope that CIPL will organize in the upcoming months. Thank you so much, guys. And we hope to have you guys around here when things start reheating in the Senate. And luckily, you guys will be able to be here in face-to-face with us. Thank you.
Thank you, Diego. Felipe.
Same. Thank you so much for putting this together. I think that it's quite amazing to have, you know, colleagues from different perspectives. Miriam, of course, with the NPD, and Thiago as well. You know, having been a member of the Senate committee, it's so important to, you know, have you know, just have their perspective, you know, and understand what was taken into consideration when drafting the bill. And also my colleagues from other companies, it's great to see, you know, what's on your mind and what's most relevant from this bill on your perspective. So yeah, thanks so much.
Absolutely. Thank you, Felipe. And Renato.
Matthew, real quick here, because I really wish we had a little bit more time to discuss issues such as generative AI. I don't think that the bill as it is right now, it really has all the tools that we need for general purpose AI, even when it tackles different liability regimes for those who develop general purpose AI, specific types of AI, and so on. For example, I believe that right now, LGPD is more equipped to focus on the issues of generative AI than the bill 2338. I even invite ANPD to maybe bring this discussion up on issues such as different legal status of public available data that is used for pre-training and input and output. We had a question here from someone that was asking IP issues. The bill as it is right now does not focus on so much, it focuses IP hallucination in what it does. So I believe that the same way that we saw in the end of 2022, OpenAI changed the entire discussion ecosystem of AI in the EU and the rest of the world. Now I think we should be on phase 2 or new phase to further discuss some items that we need to include or detail more, have a different approach on the bill 2338. And thank you, CIPL, for taking the opportunity for this, all fellow panelists. Looking forward for continuing these discussions.
Renato, thank you. And my apologies to skip to give short shrift to generative AI. This is definitely a call to action for us to do more work on this space for sure. Bojana, the last word over to you.
I mean, look, fantastic conversation. So thank you, Matthew, for leading this and everybody for really working so hard on this. And the panelists, you are great. And this is why we need to have these conversations. I think we heard we need a part 2 or maybe even part 3. We will do that. Let's plan for that. And you know, with some input as to what these specific deep dives can be. But let's go into several deep dives on a next webinar. I think there is something that I would like us also to see. What can we learn from data protection discipline, that we can actually translate into this new AI world, so that we don't duplicate. There are so many concepts here that really are the same, and I kind of feel certainly data privacy management programs can be leveraged, and the accountability, the way Samantha has very nicely explained, can be leveraged for AI, but lots of concepts around transparency and fairness and explainability, maybe they'll be different, but I think there are lots of them are the same. So, I think it's important to explain that to those who are not in data protection world, right? They don't know how this works with us. And I think that would also stop probably over-regulation. And with that, I mean, yeah, you don't have to invite me. I love Brazil. Anything that we can do to get there, I'm always for it. But really look forward to another webinar if we don't see you. And maybe we will see some of you at the IIPP Washington Summit. Actually, we will have an interesting discussion. Maybe, Matthew, I can just say that with the Atlantic Council on Thursday afternoon, I think from 3 o'clock. Those of you who are in Washington, please join us. It will be a live event on this transatlantic global policy and way to regulate AI. What brings us together then perhaps puts us all apart? So we want to look into the sort of similarities, but also see whether there are different approaches as well. So a little plug to come to that, please.
Thank you. And I see that will be great. Thank you so much. Muito obrigado. Thank you, everyone, for your time, and look forward to continuing the discussion.
Bom dia.